Guys, we're back again with a very special guest. Today we have none other than Nicholas Spatola, an excellent IP attorney and overall business-minded, mechanically minded professional who's always been great to work with, and we've had like really good success working with Nick. And I want to introduce you guys. Tell us a little bit about yourself, Nick.
All right. So thank you for the kind words. Just your average technical guy. I have a love for patent law. I started off in engineering. It was fun, but not my passion. Went to law school, really found it. And, anything that deals with IP law, I'm interested in. I'm the technical guy that'll help whoever through.
Good stuff, man. I've actually known Nick for a while, man. And Nick has an office upstairs from my office. There are a lot of conveniences of working together with Nick, and I'd say one of the most important things is that whoever you work with, man, if you can call them and they actually pick up their phone and get back to you in a reasonable time, I mean, that already makes you like an exceptional human in this day, professional this day and age. Yeah. A lot of times, it's hard to get a hold of people. So I'd say I mean, whatever, take it for what it's worth. But you're always amazing at getting back to clients, and I've heard that feedback from a lot of people. I don't know, I just have a couple notes here, and just kind of chat, and I like to keep this a loose conversation, kind of just about learning about the ins and outs of patent law, how to protect, and if anybody has any questions they want answered, you can comment, and we will in the future do another podcast. If you got a question for Nick here or for myself, we'll answer those in future podcasts. If what you learn from this podcast, this conversation helps you, then then give us a like and a share, subscribe, ring the bell, all that stuff, man. And so we're gonna start her off, little Nicky. Here we go, buddy.
Let's go.
Ready? All right, Nick. So we talked a little bit about this before, man. But like roughly, how many projects do you think that we've done together?
Probably done about like 20 projects together recently. Okay. Yeah.
Cool. And just, do you have like a rough idea of how many of those went in and got patents awarded?
In general, it's about 90%.
Nice.
Yeah, we do a lot together, and you guys put a lot of detail in, which is very important too for when I go in there, right? I'm responding to the USPTO that I have something substantive to go back to them about. So that's why I think we've had a high success rate together.
Nice. That's a really good success rate, I'd say, man. I mean, 90%. I think with getting things patented, I think anything over 50% is probably a good rate. It's not easy to get patents unless they're like extremely narrow, right?
Right.
So here's a nice slow ball for you, man. You ready?
I'm ready.
Let's just get it warmed up, man.
Ready?
Into it. You want to ease into it? All right. What's your second best piece of advice for somebody coming into has an idea, they want to figure out how to protect it, they have a limited budget?
Right. It's really, you have to speak with your patent attorney and let them know all the information, right? Because I'm going to come back to you with a proposal, and I'm going to tell you what I think you need to do. Now, the biggest mistake I could see with that is if a client looks at certain areas and says, well, I'm not going to do that, I'm going to hold off on that. And then they choose services which actually don't benefit them, right? I think we've talked in the past about design patents. Now, that could be beneficial, but in certain circumstances. Right. So if you're not talking about your whole strategy with your attorney, I might recommend something. You might think something is kind of out of reach, but in reality, I could work backwards, right? I could take what you want to do, what your budget is, and then figure out a plan for that. So always speak with your patent attorney, because you're going to get something tailored to it, right? And if you have a low budget, that's fine. There are strategies we can employ to kind of help spread things out a little bit, because there are certain services that are going to be more valuable than others. Let's be honest about it.
All right. So let's say that I'm a new inventor, right? What budget should I have in mind, if I'm trying to protect my idea? I like to talk about difficult questions that most people avoid, right? I think that's the most value I can bring to my community, the people that listen to me, is asking difficult questions and being able to talk it through, So
yeah, I mean, listen, if you're money minded, your day one budget, I think if you can handle 3,000, you're going to be opening up a lot of doors for yourself. Right? A basic patent, provisional patent, that is, 1,500. And you as the inventor are going to be doing a lot of the writing there. What I'll do is I'll kind of go over it, speak with you, and then file it. But that's very basic. But that'll get you something filed. That'll get you a filing date. And a provisional patent is actually, I use this analogy with a lot of people. It's like building a house, but if everything came to that lot day one, right? So it doesn't have to have all the formalities of a patent application. You just need to make sure the wood's there, the appliances are there, the flooring's there, in huge piles everywhere. But as long as you can put that down, I'll take that and file it.
Yeah.
You know, a patent search is also important to do early on in the process, just to make sure the idea is feasible. But those are two of the biggest areas to start off with. And if you have, you know, anywhere between 1,500 and 3,000, you could start the ball rolling.
All right. And so what does $3,000 get me?
So as I mentioned, you know, 1,500 for a basic level provisional. You're gonna have to pay the government.
Is there a range that you like to?
Yeah. So
because I mean, I've heard of provisional patents costing. I mean, I've paid for a provisional patent before $3,500. It was a complicated product with electronics. So, you know, I like to. There's a range, right? Like
1,500 is really the floor, right?
Okay.
And that's to give you a filing date. I'm not really doing much on that. You as the inventor are doing most of the work.
And what if let's say I have an idea and I want you to help me describe it better and, you know.
Then you're going to start for, I guess, something simple, probably around like 3,500, where I'm going to go in, I'm going to start putting together some of the stylistic. It might not be a very robust application, but that scale slides up. So the more we do, we could go all the way up to a full-on non-provisional and just file it as a provisional application. You know, you could have a software application where you're filing almost a non-provisional for like 15,000. So it's a wide range in there.
So that's actually brings up a good point. You know, Lime Design we've like cut our teeth with physical products, right? And we're actually now, and then moving in, you know, the first couple of years of Lime Design was mostly physical products, you know, things that aren't as complicated. And I think, you know, as time goes on, it's just more and more important to understand the whole, you know, the whole picture, which is basically including products that are smart, right? That have electronics, that have applications. So how does it work when you're working? Let's say it's an app. Do you treat it the same way as it's a physical product?
It's actually a great question because there are more nuances to software applications. You know, I don't want to go too much into technical detail, but there is a major issue that plagues inventors, which is called an abstract idea, right? You get a rejection under 35 USC 101, and the issue is you can't patent math, and all of programming is math-based. So one of the things as an attorney that we look at is, one, is there any technical aspect of it, you know, a certain type of specific electronic? You know, is it more than just the abstract idea, right? Is it a practical application of that abstract idea? And you need to work with your patent attorney very close because there are certain stylistic aspects of it that we need to incorporate, right? That almost seem trivial. You know, you're going to want to start with explaining some of the basic level components, right? You're going to have a processor, you're going to have a memory, right? The program is going to be stored on that memory, right? You might write the claims in a way that says, you know, a process stored on a memory that when executed performs the steps of X, Y, Z, and that's where you go into the steps of your application. And you try as much as you can to relate those steps to the physical pieces. So like a transmitter, a processor, what happens to produce that outcome. And so there's a totally different process that goes into it. Flow charts are the best friend of anybody doing that because a flow chart shows how your program works. You don't necessarily need to put coding in there. It can help if you put snippets of it, but you know, again, to your point, it is a totally different process because you kind of have to be thinking in 4D there.
And the reason I asked that is because, like, I've been changing how, you know, how we even quote projects, right? Because before I didn't have to take as much stuff into consideration. You know, we're figuring out, you know, it's different when you're just figuring out like basic, you know, plastic shell enclosure for a product. It's different when you're in charge of the electronics on the inside and how that's going to communicate with an application. So I've had to change how I quote a lot because when a client comes to me now, and I'll do a little bit of, you know, plug for myself here or whatever, you know, when a client comes to me, if it's a physical product, you know, we have a price. So when you're talking about complexity, right? There's the physical, enclosure for a product, let's say, right? And then you have the electronics, and you have an application in a lot of time, in a lot of cases. So it used to be so easy to quote projects. Because I wasn't involved in more complicated things. But knowing that, and I'm expecting it to also affect the price of a patent and a provisional and utility patent, based on that kind of complexity,
Yeah. Well, I mean, it'll definitely affect the non-provisional application. Like I mentioned, that $1,500 floor, if an inventor feels they're very tech savvy and can really explain their invention, put a lot of information down there, I could just take that and file it. That's one thing that you and I have done very well with is you'll provide a tech pack for me. I'll look at that. I'll put the cover sheet with it. I'll make sure what's there is there. I might send like a template to the client to fill out to make sure the parts and pieces are there. But, that's the thing. I could file the minimal. So, I don't want people to think that 1,500 is where they should go. That's I don't have a lot of money, but I need something filed ASAP.
I kind of think that speaks to, I guess, your flexibility as a service provider, right? And basically, if somebody's very hands-on and they're doing the majority of the description and the writing, and you're basically looking it over and understanding it and submitting it, right? Is different. So then if you're doing all the writing and getting all that information out of that person's mind and doing copy back and forth, right? So range is 1,500 to 3,500 roughly for provisional.
For a non-provisional, yeah. Oh, sorry, for a provisional.
Provisional, yeah.
But that's the thing, right? Because with the provisional, there's no formalistic requirements, right? As long as you're providing the information, it's there. It's when it gets into the non-provisional that it gets a little more hairy, and I like to control the final product.
Something that I want to talk about a little bit is like, what do you need visually to provide to fill out this NDA? Excuse me. What do you need physically, like visually, to provide, to a patent attorney for a provisional patent?
So the biggest hurdle that people need to do when they're filing a provisional is making sure that someone can look at this and see what the invention is, right? So you might be able to do some of that with words, but you're obviously going to have to put figures in there. So you want to make sure that you're showing all the views of this. If it's technical, it makes it easier because you could see what this product looks like. A lot of times too, if you're doing a design patent in tandem, right, you could focus on the 7 main figures, which is front, right, left, top, bottom.
For provisional?
For provision, you can put that in there.
I mean, but I guess, look, I sorry, I apologize. I didn't phrase this, I guess, as I intended, I guess. But so yeah, you could pay for technical drawings are created and showing all the orthographics and an isometric, right?
Right.
The 3D. But do they need that to fill out the provisional?
Not necessarily. And honestly, if you want to describe it with words and just put a couple sketches, that's fine.
So I guess and the reason why I'm leading to this is because I like to introduce a patent attorney on our projects early in the process. Typically, once we've started and done our research, so we understand what we're talking about, and then we've done some market analysis, so we understand, direct and indirect competition to the client project, right? And we'll normally take it to like this image right here, right? So we sketched it out and rendered it basically in. It's a digital 3D rendering done by sketching, right? Like similar to a Photoshop process or,
Yeah, actually, this is really good. And we've worked on this several times with shared clients where I'll call you and say, Rodrigo, this is what I need to show, right? This is the client's invention. These are the key aspects that need to be in that illustration. So when I'm writing the provisional, I could reference it. They don't have to be in final form. They just have to be in a way that someone looking at it can look at the written text and kind of follow that idea with it, right? So stuff like this, sketches, things like that, perfect. As long as I could see from the illustration what's going on. Even something like this, right? With just hand sketches, things like that. But just so long as it mirrors what we're putting in the writing, right? And that's why those tech packets are great because they have some of the writing, they have a lot of different variations of it. And actually variations can be good too, right? Because you don't want to limit it. So if you have a couple different variations, it's going to kind of put that idea in there that, hey, this could be accomplished in multiple ways what are the pieces that
Yeah.
are key to this invention.
So let's say I have two variations. Does that cost more than one variation, or I mean,
Not for
how?
that basic level.
Okay.
No. But it will cost more if we start going into me using my professional abilities to start writing that. If we want to start putting together
Right.
like a sample specification, or if we want to start annotating those drawings, yeah, the more embodiments that are in there.
Yeah.
Because the other thing too is we're going to have to look at the claims, right, and what the claims disclose.
Hmm.
So if there's multiple embodiments, we're going to have to take a holistic view of this and say, okay, what are the key features that fit both of these embodiments, and how can I put them both into that one claim so that way it covers both of them.
See, it's never as easy as people think, man. I think just in general, it goes so much deeper. And in general, I just want to thank you for taking the time and being here for us and for helping. I mean, this is an education and an introduction to somebody that I've worked with for a long time. And so yeah, I'd love to just take this opportunity to thank you, man. Appreciate you.
Yeah,
Your time,
absolutely. I mean, the whole SFID ecosystem, right,
man.
is a great idea. Combining the different leaders in those industries, whether it be legal, whether it be prototyping, whether it be development, and just putting them in one house. I mean, this is the third location I've known you from, but we've grown since then. But I think it's definitely a nice marriage of skills right here.
Yeah, yeah. Hey guys, thanks for checking out our podcast. Part 2 is even better, man, because there's so much information in that one. So definitely check that out. Nick has a ton of good information in his head that he shares with us. To see the part 2 of the presentation, click on the link below, and we're going to be getting into a lot more detailed patent talk. So check it out and get your mind blown. I'll see you guys there.